Is a complaint that alleges that New York City's property tax system is broken valid? To find out, you have to read Tax Equity Now versus City of New York, but it's 58 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Tax Equity Now versus City of New York. The citation for this case is 2024 New York Slip Opinion 01498, published by the New York Court of Appeals on March 19th of 2024. The issue in this case is whether a complaint alleging that the City of New York has violated the Fair Housing Act and New York state law and constitutional law is legally sufficient to be sustained and upheld and allowed to see a courtroom. To understand and appreciate the context of this case, I think the background that's helpful to know is that under CPLR, Civil Practice Law and Rules, 3211A7, that's a motion to dismiss. A party can move to dismiss a complaint under that ground, under 3211A7, on the basis that the complaint fails to state a cause of action, that even if you assume everything in the complaint is correct, assuming all the allegations are true, there's no remedy, there's no relief to be given based upon those allegations. When assessing that, the court is supposed to provide a liberal construction, supposed to view it and accept all the facts as alleged as true, and giving the non-moving party, which is the party the party that has the complaint, the benefit of every possible doubt and inference, determine whether those facts, as alleged, fit within any cognizable legal theory. So because the consequences are so severe of granting the application to dismiss a complaint, you have to look at it, assume everything's true, and say, is there any relief to be given if everything's true? So what are the facts in this case? The facts are that in 1981, the New York legislature passed Article 18 of the Rptl, the Real Property Tax Law, establishing a very complex system of how the city of how to assess taxes. And the city has 4 different classes. Class 1 is single, double, and triple family residential property, up to 11 units. Class 2 is all other residential property, including co-ops, condos, and rental buildings. Class 3 is utility property, and Class 4 is all other kinds of property. And essentially, using these 4 different classes of property, classes 1, 2, 3, and 4, the city has to sort of figure out how to make up its tax base, how to assess property tax values to get what they need for their budget, because the single biggest revenue stream for the city is its taxes. Okay. There's several other statutes that are implicated here. Rptl 581, which states that real property, it's a law that says that co-ops and condos are assessed at a sum not exceeding what they would be if they were rentals. Essentially, Rptl 1803 provides a formula for determining the proportion of real property taxes owed by each class. It's a very complex process. There's also partial tax abatements. But the important part here is that in 2017, Tax Equity Now of New York, which is an association committed to pursuing legal and political reform with respect to taxes, filed this complaint alleging that the way the city is operating its tax structure and assessing taxes under classes 1, 2, 3, and 4 is improper and unconstitutional, unlawful and unconstitutional. They allege that the city's tax system is inequitable. It's not based on fair market value as required by state constitution and the real property tax law. It has a discriminatory impact. In particular, they say things like this. They say that the law requires that property within classes should be taxed the same way. Like class 1 should be taxed against the same way as other class 1s, but they're not. They say, for example, a property in Canarsie, Brooklyn is taxed at 3 times the rate as a property in Park Slope, Brooklyn. And they say that the result of this is that the impact of tax revenue burdens fall more distinctly on ethnic minorities in the city, and that also on people that are renting versus condos and co-ops. They say that condos and co-ops are compared for their tax burden purposes and tax assessment purposes against rental buildings. So if you buy a $200 million condo, which happened last year, a $200 million condo is taxed as if it's a $12 million condo. Why? Because it's being compared against rental properties, not against itself or similarly situated condos or co-ops. So they make this complaint. The Supreme Court denies the city's motion to dismiss, but grants the state and federal motions to dismiss. Goes to the Appellate Division. They grant the city's motion to dismiss, dismissing everything. So there's no more complaint. It goes to the Court of Appeals. And here, there's a majority and a dissent here. It's 4-3 decision here. Under the majority, he basically says, under the liberal pleading standards, forget about the complexity of what's going on with the real property tax system. It's sufficiently pled. The majority says it's sufficiently pled. All that's required is a complaint being alleged that's sufficient under any cognizable legal theory, and it is. They say it's sufficiently pled that there's an Rptl 305 violation because, as I said, class 1s should be assessed in the same way as other class 1s. If you buy a $500,000, this came from the oral argument, if you buy a $500,000 building in the Bronx, it should be taxed the same as a $500,000 building bought in Manhattan, and they're not. But they should be, according to the complaint and according to the court's decision. That is a sufficient allegation that would justify being at least going to a trial, having discovery, being subject to a motion for summary judgment, but at least it should be allowed to continue. That's what a 3211A1 question is. And also, the allegations are sufficient for a Fair Housing Act violation because it's unlawful to discriminate on the terms and conditions and privileges of sale. And here, the allegation is that this is resulting in increased segregation, ethnic and racial segregation in the city. And that is a sufficiently pled complaint on that ground. So they reinstate the allegations as against the city. The state remains out. And that's the case of Tax Equity Now versus City of New York. It is sufficiently pled. The case is reinstated for those purposes. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.